Hello, good people. Thank you for joining me. My name is Marwan McRae with McRae Law Firm, where I provide estate planning, probate, and estate administration legal services. My objective with this video is to give you a basic understanding of estate planning, and I've put together a presentation to share with you. But before we jump into the presentation, you may be wondering, do I even need an estate plan, or can I afford an estate plan? To both questions, my answer, generally speaking, is yes. To the first question, do I need an estate plan? Well, I hope you could agree that just as surely as we're all born into this world, that we all will leave this world at some point in time. And whether we're 25 or 85, very few, if any of us, knows the date, time, and place of our last breath. Therefore, if we have any loved ones, such as a spouse, a minor child, or an incapacitated adult child that we are caring for, and we wish to ensure they're cared for after we move on, then it's important to provide a list of instructions regarding their care. Additionally, if you have any assets, such as homes, automobiles, boats, family heirlooms, cash, or investments that you would like to leave to certain individuals or to charities for that matter, it's important that you capture your wishes in a formalized document. And that is the general purpose of estate planning, to capture your wishes regarding your self-care, care of loved ones, as well as asset distribution in a formalized manner that is recognized by the state in which you reside. And do keep in mind, if you neglect to put in place a plan to provide the care or to distribute your assets, the state will do so on your behalf. But unfortunately, in many cases, they do so in a manner that you would not agree to had you been living. And so to ensure that your wishes are honored, it's important that you put in place an estate plan that expresses your wishes, again, in a formalized manner. In terms of the cost of estate planning, those costs are largely driven by the complexity of one's wishes, as well as the content and value of the assets. So for most people, the estate plan is relatively simple. Therefore, the cost of the estate plan is surprisingly affordable. Therefore, I would encourage you to reach out to local attorneys who provide estate planning services and set up a consultation with them to better understand what they recommend as well as their costs. And for people who have concerns regarding their ability to afford legal services, many communities offer volunteer services that provide estate planning at little or no cost to the client. Here in Houston, Texas, I'm a part of the Houston Volunteer Lawyers Organization that provides free estate planning services to individuals who are either at or below the federal poverty level. Now that I've briefly touched on the need and the cost of estate plans, let's now get into the presentation. And bear with me for just one moment, please. Again, the topic of this presentation is Estate Planning 101. And to help me move through this presentation, I've enlisted the help of my fictitious client, Al. Al is 36 years old, married, has 2 children, works in aerospace, and resides in West Texas. One day, I was up late watching TV and saw a commercial for life insurance, and during that commercial, estate planning was mentioned. Therefore, the next day, Al called me and asked, "What is estate planning?" Now, before I get into what is estate planning, I think it's important to first establish what is an estate. And true story, had you asked me years ago, this is what I would have imagined the estate being. And while this is an estate, this is not quite the estate I have in mind regarding this conversation. Rather, in Texas, the definition of estate in part says it's the real or personal property of a person who is either incapacitated or deceased. And just to clarify, the distinction that it's the property of a person who is either incapacitated or deceased necessarily means that the estate cannot exist while the person is of sound mind and living. and therefore the estate is not created until either the person loses mental capacity or is deceased. Now that we've established what is an estate, Al next had a question: what is estate planning? And so back to his original question, estate planning is the process of anticipating and arranging the management and distribution of a person's estate in the event of a person's incapacitation or death. And so with this definition of estate planning in mind, I was curious about the purpose of an estate plan and why he should put one in place. Well, Al, the purpose of an estate plan is to specify how, when, and to whom your property will be distributed, to identify who will oversee your affairs, to document your wishes regarding final medical care, to protect minor children or adults under your care, and to minimize the probate administration process and its expenses, delays, and loss of privacy. Now that we've discussed the purpose with Al, now Al's next question is, what do I or should I include in my estate plan? And glad you asked, Al. In your estate plan, the basic documents are the last will and testament, trust, durable power of attorney, advance directive or living will, medical power of attorney, HIPAA authorization, guardianship designations, and letter of intent. There are many other documents or measures that may be included in the estate plan, including life insurance and pension policies, any funeral policies and things like that. However, the documents listed here are the basic documents that should be included in most estate plans. Now that I've given you a high-level list, I'll go into a little bit more detail for each document. The first document, the last will and testament, is a legal document in which you identify your beneficiaries, specify how your property will be distributed after your death, assign an executor to manage your estate, and also to nominate a legal guardian for your minor children. Now keep in mind, while we execute the last will and testament during our lifetimes, the last will and testament does not take effect until after we die, or in some cases, in the event we're incapacitated. The next document is the trust. A trust is a legal document created during your lifetime in which you designate a person called the trustee to manage your assets for the benefit of the eventual beneficiary. And with a trust is similar to a will in that it is intended to dispose of your assets as well as to provide instructions for care. However, unlike the last will and testament, the trust can be executed during our lifetimes, but it can also take effect during our lifetimes, and therefore we can transfer assets into the trust or have certain care benefits provided in the trust while we're still alive. The next document is the durable power of attorney. The durable power of attorney is a legal document which authorizes your designated agent to take certain actions regarding your property and financial matters, but, and this is an important distinction, but not your healthcare decisions. With the durable power of attorney, this person has authority to purchase or sell real estate, to purchase or sell stocks or bonds, to purchase a life insurance policy or cancel a life insurance policy, or to modify your pension or 401k. Therefore, as you can see, the durable power of attorney may have a broad breadth of authority to make changes that affect you. Therefore, you want to choose somebody who you thoroughly trust. And also, in terms of any limitations you would like to impose on the sale of real estate or investments, it's important that you include those limitations in the durable power of attorney document. The next document is the advance directive or living will. The advance directive is a legal document which communicates your wishes about medical treatment should you become incapacitated. And the medical treatment could include things such as whether you want CPR performed on you, whether you want to be otherwise resuscitated, whether you want to be ventilated if you can't breathe on your own, or intubated, if you cannot feed yourself, or whether you wanted to be resuscitated in the event you go into a coma, as well as blood transfusions. And this document captures those wishes to be provided to your loved ones as well as to your healthcare providers should you be in a situation where you can't make the decisions for yourself or communicate those decisions to others. The next document is the medical power of attorney. The medical power of attorney is a legal document which authorizes your designated agent to make any and all healthcare decisions for you based on your expressed wishes. And to point out, generally, the medical power of attorney works hand in hand with the advance directive, and oftentimes they're combined in one document, such that the agent listed as your medical power of attorney primarily provides instructions based on what you included in your advance directive. And if the medical power of attorney, the agent, if they give any instructions that are contrary to your advance directive, in many cases, the advance directive will override the agent's instruction. The next document is the HIPAA authorization. HIPAA authorization is a legal document which authorizes a covered entity to use or disclose your protected health information for purposes not otherwise permitted under the HIPAA Privacy Act that was passed in the late 80s. And so with this document, again, if there is any pertinent information regarding your healthcare, by signing this HIPAA authorization and producing it, you give an entity authority to share medical information about yourself. And it can be complete information or partial information. It's just a matter of which you specify the level of authorization you provide in the document. The next document I'll speak about is the guardianship designations. Guardianship designations are a legal document which specifies the person you wish to be appointed to care for your minor children and or to manage your estate, financial activities, self-care, and or healthcare decisions if you're not able to make decisions known for yourself or make decisions on your own behalf. One thing to keep in mind with the guardianship designation is while it is a statement of your preferences of guardians, the courts may or may not honor your wishes. So it just depends if the person that you designate is still a minor and not able to legally make decisions, if the person is incapacitated, if the courts determine that person is unfit to make decisions on your behalf or on behalf of a minor child, or the person elects not to carry out the responsibility, then the court or a government agency may choose another guardian to carry out the responsibilities. And so that's why it's important that in addition to the primary guardian designation, you also provide alternates in the same document. Therefore, if for whatever reason the first agent is or guardian that you desire, your first preference is disqualified, then you have somebody else to fall back on. Otherwise, the court will choose the guardian, and it may be somebody that you would rather not care for you or for your minor child. The last document I will discuss is the letter of intent. The letter of intent is a written expression of your wishes to guardians, executors, beneficiaries, and other interested parties regarding asset disposition, care of minor children, and or healthcare preferences upon your incapacitation or death. One thing to keep in mind with the letter of intent is it is not a legal document, and so it's not binding in any sense. However, one of the benefits of the letter of intent is should any loved ones or other beneficiaries in your estate plan challenge your actual intentions and desires, the letter of intent is a more prose-like description of what your wishes are. And so in many cases, it helps to calm any disputes or tensions that may arise at the time of distribution of assets or decision-making upon the care of a minor or your own care. Also, in Texas, generally the courts will honor the estate plan. However, in some instances where documents in the estate plan provide either ambiguous instructions or the instructions conflict with the law, the courts often are required to reform the document in order to clear up any ambiguity or to resolve any conflict with the law. And in that case, it's either you'll be incapable or incapable of expressing your wishes, or you will have passed on. The courts may look to the letter of intent for further guidance as to what they believe your wishes may have been. And so the letter of intent may serve as guidance to the courts or government agencies what your wishes were or are. Now that we've covered the basic documents of an estate plan, I was curious, what are the next steps? Great question, Al. I'm glad you asked. Should you wish to move forward, I will provide you with an estate planning questionnaire. The estate planning questionnaire documents your name, your spouse's name, your children's name, any executives or executors, guardians, or agents who may act on your behalf, a list of your assets and who you wish your assets to be distributed to and when, and other information such as personal care or the care of a minor, any policies you may have, or things like that. In addition to the estate planning questionnaire, I'll also provide you with instructions for letter of intent, again, to make your wishes known in prose-like form for the review of loved ones in case any concerns arise, whether the trust or will or the power of attorney documents actually honored your intentions. And so again, the letter of intent is just to capture your wishes. And so that pretty much covers the basics of estate planning. So again, we've covered what is an estate, what is estate planning, the purpose of estate planning, and the contents of estate planning, as well as the next steps. And if you have any questions, I firstly appreciate your time. If you have any questions, again, my name is Marwan McCray, and you can reach me at email you can reach me by emailing me at mmcrae@mmcraelaw.com, or you can call me at 281-650-9357. Again, that number is 281-650-9357. Lastly, please visit my website at mmcraelaw.com, where you can schedule a free 30-minute consultation to have any questions answered that may arise or to discuss your estate plan. During that 30-minute consultation, I will address your questions and just give you my basic thoughts on what should be included in your estate plan and how you should go about implementing it. So again, I thank you for your time today, and I wish you all the best. Many blessings to you, and please stay safe. Thank you.